Now, our last speaker of the day, very much looking forward to hearing from Gerard, as I know a number of others in the room are. Gerard Phillips is one of Australia's well-known industrial lawyers, having been in private practice in this area for over 25 years. He's a partner of the Labour, Employment and Workplace Safety Group at K&L Gates, a global law firm. His client base is large corporates in unionised industry. He is a frequent author in the Australian Financial Review and the Workplace Review on industrial relations issues. And today, Gerard is speaking on should Australia adopt the United States RICO legislation for dealing with corrupt trade unions. Please welcome Gerard.
Good afternoon, everybody. I think I've heard some of the earlier speakers here talking about Hayden. I mean, really, what the key with His Honour's considerations Royal Commission will be not so much as what's in them, but what happens in the Parliament with them later on. So, I think as a brief overview of the paper, we should take a quick tour through the Royal Commission's past that have involved trade unions and see where they got us to. Since 1974, there have been 5 Royal Commissions created by the Commonwealth touching upon union activities. The first one in 1974 dealt with alleged payments to maritime unions. The next one was the famous Costigan Royal Commission into the Federated Painters and Dockers between 1980 and 1984. In 1981 to 1982, the Australian Building and Construction Employees Royal Commission took place, and that was the Royal Commission which led to the demise of the BLF. There's then a gap until the Coal Building and Royal Commission, the Coal Building and Construction Industry Royal Commission between 2001 and 2003. So that gap corresponds with basically the Hawke-Keating period of 83 to 96. No Royal Commissions at that point into trade unions, and of course now we have the Hayden Royal Commission from 2014 to the present time. So if you look, it's 40 years, 5 major inquiries at Commonwealth level. So in effect, 1 every 8 years. That goes down to about 5 and a bit years if you take out the Hawke-Keating period. The states, of course, have had a number of their own Royal Commissions, notably the Giles Royal Commission into productivity in the building industry in New South Wales. The report was published in 1992. In preparation for this speech, I went back and had a look at some of these Royal Commission reports, and if I go to the Coal Royal Commission report in 2003 and compare that to what we're watching with the Hayden Royal Commission now, I'm reminded of a quote from one of my favourite philosophers, which is the wonderful US baseballer Yogi Berra, who once said it's like deja vu all over again. The Coal report found significant and widespread circumstances of intimidation, threats of violence and breaches of freedom of association, trespass and interference. In Victoria, Coal said that there is an urgent need for reform and cultural change as the rule of law has ceased to have application in the industry in the state. It found that all of the state's major construction projects were beset on a regular basis by industrial action, almost all of it unlawful. Coal found in Queensland that the unions were attempting to control labour hire in situations only of genuine top-up payments, having the effect of supporting preferred labour hire companies. In short, distorting the price of labour in that market. And in Western Australia, Coal found that the construction industry was marred by unlawful and inappropriate conduct in a culture of fear, intimidation, coercion and industrial unrest. So, I think you've all heard that old saying, the more things change, the more they stay the same. Here are some quotes from 2 prominent union officials in about 2001 commenting upon the proceedings before the Coal Royal Commission. The then ACTU Secretary Greg Combay said this Royal Commission was politically motivated and its establishment and it's biased in its conduct. Sounds pretty familiar. He rejected the need for a new body to police construction, saying that the existing law enforcement agencies were sufficient, and I think history has proven Mr Combay to be completely wrong in that statement. John Sutton, the then CFMEU Secretary, said that the $60 million spent on the Coal Royal Commission had been a massive waste of money. All of these Royal Commissions examine the industrial legislation, and necessarily so. They looked at the acts governing industrial laws and those governing registered organisations. Discrete bodies like the ABCC were created as an adjunct to the industrial laws. Their recommendations went up to Parliament, some were adopted, and I'll come back to that. So why are we here in 2015 with Dyson Heydon basically looking again at similar behaviour, albeit through the lens of internal governance of trade unions? I think I'll go back to Mr Berra again. We've made too many wrong mistakes. And what were these wrong mistakes? I think it's a combination of a range of things. The first one is the Royal Commission would give us all the answers. They don't. As you know, Royal Commissions are given terms of reference and they are bound by them. Oftentimes what happens is that evidence comes up which may be marginally relevant or not to those terms of reference. All the Royal Commissioners, usually retired in a High Court or Supreme Court Justices, they will, as far as possible in their recommendations, try and stick to the terms of reference that they're being given. So you'll hear a whole lot of evidence about things which may be sensational or shocking or whatever. If they don't have any relevance to the terms of reference, don't expect a huge amount of airplay about them in the report. Not every recommendation made by Royal Commission will be enacted by the Parliament, and that's, I think, the first comment I said earlier. The big battle with every Royal Commission, whether it's with trade unions or anything else, is what happens with those recommendations in the Parliament later. Nextly, governments change. As you saw during the Rudd-Gillard era, it was a relatively simple thing for the industrial laws to be changed, and the ABCC at that point being denuded of much of its power. So post-coal, the construction unions were back in business. Perhaps most importantly, the various Royal Commission's reports did focus on the industrial laws, but perhaps we were focusing on the wrong vehicle in order to deal with the range of conduct that was revealed during the Commission's hearings. I include Heydon in this because truly his brief is to look at internal union governance. Now, clearly the evidence has shown that it requires a significant review, but a whole range of other conduct, and conduct the previous speakers was dealing with in the competition zone, is really not relevant to what the thrust of what Dyson Heydon will be looking at. As you all know, the industrial laws exist to prescribe awards and how agreements are made and other legal issues to deal with employment. They're not part of the criminal law of the state. Further, it's obvious that some unions simply see breaching industrial laws as just the cost of them doing their business. Think about the Grocon dispute here in Melbourne a few years back. Clearly, dispute orders that were made by the Commission were insufficient to deter the union at that point from the path that it had embarked upon. You're seeing similar things now about the Alcoa ship Portland. Orders are being made and they're being not observed. And as you see, the Heydon Commission recently made no recommendations about a series of side deals entered between unions and employers for favourable enterprise agreement outcomes. Now, these deals are not available to everybody in the industry. They distort the market for labour and place those outside the deal at a competitive disadvantage. So in short, people might look at this and think that the playing field in which they're competing is not even. In my view, we've been looking for answers to many of these questions in the wrong places. In the past 40 years of Royal Commissions, what we've seen is that while some outcomes have occurred which have curbed behaviour, the BLF was deregistered, the underlying lawlessness and intimidation in much of the construction and maritime industries in particular have endured. Improvements like the ABCC were unwound. So what I think we need to do is an approach which does not focus on the industrial laws alone. Because as we've seen, the unions and their politicians will repeal or water them down upon reaching government. So what would a new approach look like? In the 1970s, in response to mafia activity in the United States, the US Congress passed the Racketeer Influenced and Corrupt Organisations Act, or RICO. It was initially aimed at organised crime, but its application has been broadly applied since to nearly every circumstance that involves long-term criminal or fraudulent conduct, including financial fraud. In the US, its reach has extended from organised crime, which was its initial focus, to cover such diverse enterprises such as the churches, Wall Street, unions, to name but a few. So in short, its application is general to the entirety of US society. It's a hybrid criminal and civil statute which prohibits the use of an enterprise, i.e. a union, to pursue a pattern of racketeering activity, which are defined in the RICO statute. Now, RICO prohibits groups of people acting in a common purpose to violate the RICO laws. It's a way for dealing with any organisation which commits a series of illegal acts as an organisation. So if you as an organisation are involved in a series of illegal acts, and there's a schedule in the RICO legislation which details what these acts are, both state and federal law, you'll find yourself wrapped up in a RICO suit. Interestingly, each member of the enterprise may be held liable for the actions of all members of the enterprise. In short, vicarious liability on each person within the enterprise. So in the US, racketeering activity is not limited to a particular group. It's defined to include a long list of crimes as RICO acts. Now, persons who are injured by a breach of a RICO act have recourse against the enterprise that breached these laws. So, for example, a competitor who has been injured by the unlawful activity of an enterprise is able to take action. They can take action against everyone or one person involved in that enterprise. Interestingly, for the United States, you can get attorney's fees in a successful RICO suit, which, as you all know, in the US, the winner doesn't normally win their costs. But the types of orders civilly that can be made are things like, if you've suffered damage, well, the court will order the damages to be trebled. And that can be imposed upon a single member of the RICO breaching enterprise. Now, could this work in Australia? I think coming out of this Royal Commission, we need to probably have a multidisciplinary approach. Yes, the registered organisations laws are going to be looked at, absolutely, because that's what the Hayden Report will all be about. There'll be some consequent recommendations to changes to the Fair Work Act, I've got no doubt. But let's look at the criminal law. I mean, Ken has spoken earlier about competition law, but let's look at the criminal law. Any such legislation would have to be part of the criminal law of the country and a universal application. Probably need a dedicated part of the federal police to enforce. The key with this is that any future attempt to exclude an enterprise, i.e. a trade union, from that class would be replete with political danger for the person promoting that change. I mean, you all are familiar in your various states where you come from with the law and order auctions we have every state election. Could you imagine if we have RICO-type laws as part of the federal criminal law of this country and somebody trying to remove a group of supporters from it? It is just dangerous, and I think with the types of Senate we're getting now, the minor parties would be unlikely to want to support such an amendment. In short, we're dealing with such behaviour that the industrial legislation, which, as it's existed in years or over the years, is just not capable of dealing with. We're looking at the wrong place if we're thinking the industrial legislation will deal with this. Let's look at how it might work. For example, I'm not talking about eliminating court-sanctioned protected action. So we're not messing with what's the unions see as a right flowing from the ILO. But what about behaviour which is unlawful? So it goes onto the RICO schedule as unlawful conduct, and then that is enlivened. I could see it working in a circumstance where the Fair Work Commission makes orders stopping unlawful strike action under Section 418. If that Section 418 order is not observed by the union or its members, those suffering injuries could have recourse under the RICO laws against everybody involved. As you can see, the present sanction for breaching a 418 order isn't a deterrent in some circumstances. The Commission makes these orders, and it's a discretionary activity on behalf of many unions as to whether or not they comply with that or not. What I do know is this: we can't have the same approach as an outcome of the Hayden Royal Commission as we've had to the four which have gone on before it and some of the state ones. We cannot limit our response in the present circumstances to the industrial laws only. I've no doubt that Dyson Heydon will produce a comprehensive report full of thoughtful analysis. But I would do this. I wouldn't limit my response if I was the government simply to the recommendations falling from the report, because we all know there will be a battle in Parliament as to which ones will be passed into law. I'd actually pass the report on to the Law Reform Commission, and I'd ask them to assess that along with other behaviour in Australia right now, and see whether or not American-style RICO legislation, which would be a broad application, should be considered by the Commission. What we can't have is business as usual. We can't have the report delivered, either sat on, or only parts acted upon. Unless there's a new approach, unless as history tells us, we can expect the next Royal Commission into the union movement in probably about 8 years' time. So I think, with that, I could see you all in 2023 discussing whatever the next thing a retired High Court judge is looking at dealing with the trade union movement. Either the money that we've spent and the time that we've taken on this Royal Commission will lead to something which will be embedded as lasting change, or it won't. I thank you for your attention.
Questions? Sam?
Thank you. How do we develop, or how is the Parliament going to develop the intestinal fortitude to be able to take on some of these reforms? It's almost depressing that we're sitting here after so many Royal Commissions and there's been arguably almost no action, albeit there has been from time to time. And I don't want to be sitting here in this room in 2023 talking about the same issue again, going through all of this. How are we going to do it so some action can really get taken?
I think that when I was preparing this paper, I think the key is to sever it from the day-to-day brawl, which is industrial relations, and look at it through a law and order lens. It's much harder for a counter-argument to be brought if you put it in those terms. I mean, you see in every state election, where there's this auction as to who's tougher on crime. If you frame this conduct in that lens, you will wedge the other side.
Gerard, do you have any inclination or view about whether the RICO auction you're talking about, or some aspect of it, might be an outcome of the current inquiry?
Look, I don't, because it hasn't been raised in the proceedings I've seen. It was traversed briefly by Costigan in the early 80s, but at that point it was considered that constitutionally it might be difficult here. But things have moved on since then. We've got a differently composed High Court. Who would have thought in the early 1980s that our industrial laws would have been drawn from the corporation's power when you had 5135 being used there for many years. So I think the circumstances for it are right. That's why it would need a Law Reform Commission, because it would be a big change to Australian law. But having said that, the Americans used to have, well before us, confiscation of crime, proceeds of crime legislation. We now have that.
Isn't it a wonder then that someone hasn't raised it?
Oh, well, look,
there hasn't been a submission of it?
I haven't seen one. Yeah. Haven't seen one.
It seems so obvious.
I have a question. With the example that you've given, if a union group ignored a 418 order and proceeded with the action, are you suggesting this legislation would allow that particular aggrieved party to bring proceedings, or the complaint would be made to the particular AFP body that would then have to bring it? So there's a balance of civil and also criminal outcomes that you're suggesting.
Exactly. I think in that circumstance, it would be the aggrieved party, because I think they would be the one who would have standing. You wouldn't have breaching a 418 order as part of the criminal law, but it would fit into part of the civil ramification of a RICO breach. That's how I would see it. And in that circumstance, I mean, you can imagine this, you've got 1,000 people out there disobeying an order, any one of them knowing, if I'm disobeying it, that the whole extent of all of the losses which the enterprise I'm attacking would be brought home on my head. Perhaps those losses multiplied by 3. So, there's got to be, in that circumstance, a cost to that action, because at the moment there's not. You know, it's obviously not a deterrent because at the moment you've got the MUA in relation to this Portland vessel ignoring orders of the Commission. And it really is, I think, over time, if you look at it sort of over the years, you know, compliance with Commission orders, unfortunately for the trade unions, has been a discretionary activity. You know, and so we need to make, you know, compliance with those orders, you know, once more something which they know they must comply with, otherwise they're going to lose an arm or leg.
Can I just touch on the constitutionality issue, because there's been, there have at various stages been discussions whether this needs to be a state-based law or a Commonwealth-based law to be truly effective, so that you can't, because I understand many of the US states have state-based laws as well, so you can't get out of it one way or another. And I just wonder, you know, your thoughts, under what power would the Commonwealth legislate, and would it need the states to either refer a power or to introduce complementary rules? Because you could go after things like bikie gangs and drug trafficking networks and things like that. Now, they may not, how would you capture them, I guess? An interstate trade power or something? I don't know. I'm interested in your thoughts.
Well, there's a Commonwealth Crimes Act. So there's a place where one could start. And to the aspect of it being part of the criminal law of Australia, one would be able to do that. Perhaps the more difficult part would be the civil aspects of it, and one would probably be looking almost into the competition or corporations type area to fill in that gap. But criminally, the feds have their own crimes legislation. You know, the types of activity that you'd want to prescribe, you could just amend that act.
Yeah, but just for the politics of it, to get the unfair contract laws through, I negotiated with all the senators, and in particular the independents, and we got the whole thing through, and I had a long debriefing with one of the independents afterwards, who has a long track history of voting against the government when it wants to put through these union amendments. And this particular senator said to me, "Don't come to me with something to beat up the unions. You come to me with something that's about the overall issue that gets everyone who's involved in the wrongdoing, I'll support it."
I mean, I think that's the point.
One last question.
Sorry, it's not a heavy question, but couldn't astute union lawyers be able to use hurt feelings under 18C to protect themselves, seeing it seems to be protecting everybody else?
I'm sure they would. Especially in Tasmania.
I'll take one last one. Yeah.
I guess what I'm concerned about in this proposal is proportionality. I mean, you've mentioned a situation where damages can be tripled outside of where damages are actually incurred. I mean, is that just?
Is it just that we have a system where we have an industrial commission which is empowered to make orders telling people to stop taking unlawful strike action, and is it just that they're routinely flouted if you don't feel like it? Is it just that the people who suffer you know, commercial losses because of that unlawful behaviour have to put up with that and have no recourse? There's got to be a deterrent. Clearly the deterrents we have now are not working. I'm saying that because that's what happens in the US. Obviously there will be a debate here, and I reckon part of it would be on that type of question, but unless there's a penalty, unless there's a disincentive, well, it'll be a glorious waste of time. The aim with this is to actually stop the conduct in the first place. To make the, and there will be people who'll breach it because, you know, I mean, you know, when we had capital punishment, people still murdered others and took the risk. I mean, you're not going to wipe out this behaviour, but what you've got to do is you've got to put in their heads that, you know, if I do this, if I breach that commission order, there is going to be some serious trouble that's going to perhaps befall my union or befall me personally. And so I'd better be pretty clear about what I'm doing beforehand. And if it takes treble damages, I'm fine with that, because your decent unionist, your normal bod who you know, obeys the laws like anyone else, has got nothing to fear from it.